do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed-
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
You'll
rights.
see how much authority I have.
The sovereign citizen looked Judge Simpson straight in the eye and demanded to know where the judge got his authority. Daniel McCauley was facing serious charges, his fourth DUI, fleeing and eluding an escape from custody. But instead of focusing on the charges, his legal argument took a very different direction. He claimed he had copyrighted his own name and argued that he had no contract with the state of Michigan. I've covered hundreds of sovereign citizen cases, but this defendant stands out as one of the most extreme examples I've seen. He was completely convinced that his arguments could challenge the court's authority. But as the hearing unfolds, Judge Simpson makes it very clear where that authority comes from, and things do not go the way this defendant expects. Let's get into it.
Sir, state your name.
I'm here on a special appearance, Your Honor, for Magoo is Easy Elastical Trust, registered in Jackson County, on a case number 2522246.
Okay, is your name Daniel Magoo?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Ms. Magoo, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No, not at this time.
Let me then do this. You have two cases before this court. The complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be
We've been
charged with
through
something
this
without a
before on
witness.
your other cases when you represent yourself, so we'll just do it.
Are you talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up 1 to 5 years incarceration.
As I am here and as a trust, Your Honor, I am here in exclusive equity. Exclusive equity. My license is
Count
canceled,
three.
not suspended or revoked. It
Count
is
three
canceled through the state
on
of
that
Michigan.
complaint.
Canceled.
A $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by
wishes
Washtenaw
to
County
represent
prosecutor as
himself.
usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or for.
This is a matter under the
Not
Eastern District of
assist you
Michigan
in
Federal
any
Court.
way, or
Case
show
number
you any
2511226.
favoritism because you were not represented by counsel. I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel would be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. Magoo has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25F30979, in that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count 1 is fleeing and eluding fourth degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
My Secretary of
2
State, anything
is
is canceled. I have no contracts with the state of
Vehicle,
Michigan.
that is a misdemeanor.
This
Charge
is a matter of trust, Your Honor. This is a matter of trust. I am protected under a trust.
At some point, you really have to ask, who is teaching these people all of this? Because this clearly isn't just one strange idea someone came up with. There seems to be an entire system of information behind it. The international driver's permit, the federal trust argument, the copyrighted name, and all the other claims. It almost feels like someone created a complete lesson plan and passed it along. And the most surprising part? He genuinely believes every bit of it. There's no hesitation on his face. He seems completely convinced that he has figured out something the court doesn't understand. I've watched enough sovereign citizen cases to notice a pattern. The more documents they bring into court, the more confident they become. They seem to believe all that paperwork proves their legal theory is working. But Judge Simpson has dealt with this defendant before, so this isn't even a new strategy for him. He has already tried the same approach in the same courtroom, and somehow, he still believes the outcome will be different this time. And Judge Simpson's reaction is almost the best part. He sits there with the calm patience of someone who has seen this exact argument before and already knows where it's going.
Jail, a $100 fine plus court cost. Count 3 on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court cost. Count 4 is operating while licensed, suspended, denied, and/or revoked. That is a misdemeanor.
All of my registrations are through the federal government. I have federal government registration. I do not have contracts with the
Vehicle could
state.
be subject to mobilization. Count 5 on that complaint alleges refusal to obey refusal to.
I have an international driver's
Police
permit.
officer. That is a misdemeanor punishable by up to 90 days, $100 fine plus court cost. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I stated in the other case also apply to this case.
Were you served your
And that
notice
if
and
the
summons yet, Your Honor?
wishes to have counsel appointed, the court would consider or would appoint counsel to represent him in this matter, and he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
until you
bench.
Inform the court otherwise. Ms. Lundy.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time?
Well, he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
All right. Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. There is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date, potentially.
Because you've got to send it.
Yeah, and who restricted my phone
Probable
calls?
cause conference. You know what?
Who?
You're going to have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say, but I'm not going to have you interrupt me and I'm not going to have you interrupt the people when they're talking.
Co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in.
This is where the situation stops being amusing and starts becoming genuinely concerning. Actual jurors showed up, took their seats, and waited for a trial that Daniel simply chose not to attend. He seemed to treat appearing in court as if it were optional. At this point, he wasn't just challenging the system. He was refusing to take part in the process while apparently believing that nothing serious would come from it. And there's more. He had active cases in multiple courtrooms at the same time, yet he was still standing in court arguing about things like a federal trust. That tells you a lot about how firmly he believed in his legal theory. Then there were the conditions of his release. He was required to wear both a GPS monitor and a scram alcohol monitoring device. Those are serious restrictions, and they suggest the court had major concerns about his reliability and compliance. Given his history, it's understandable why Judge Simpson imposed strict conditions. Some people face consequences and change their behavior. Others keep running into consequences and still refuse to change. Daniel appeared to be firmly in the second group.
And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low. And I also am going to request a scram tether, because this is an OWI 4th alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was an abuse of discretion, given the circumstances of this defendant, to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
No
I
victims.
do believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The police officer did not report that at all.
The court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash period. Thank you. If everybody doesn't mind, the court's going to take a very brief recess, and I will come back and we will finish them.
All right.
Judge Simpson ultimately increased Daniel's bond from $10,000 to $50,000 cash. And even after that decision, Daniel still described the case as malicious prosecution as he walked out of the courtroom. Think about the situation: a fourth DUI, multiple warrants, a jury trial he failed to attend, and a monitoring device on his vehicle. Yet his main argument remained that he had no contract with the state of Michigan. Now the big question is, will he actually show up for his next court date? Let me know what you think in the comments. And if you enjoyed the video, make sure to like and subscribe for more courtroom cases.